Hello friends, in the series on income tax cases, today we will discuss a very important case on the applicability of the section 147A with retrospective effect in those cases where the tribunals have quashed the assessment proceedings on the basis that the notices have been issued by jurisdictional assessing officer in spite of faceless assessing officer. This issue has been decided by Honourable Telangana High Court in the case of Principal Commissioner of Income Tax for Hyderabad versus Vinod Ojha, and this case is decided on 23rd June 2026 and the reference of the case is ITTA number 92 of 2026. The facts of the case are like this. In the present case, the Honourable Hyderabad ITAT B Bench has decided in favor of the assessee by quashing the assessment proceedings on the ground that the notice under section 148 has been issued by jurisdictional assessing officer in spite of faceless assessing officer. Same type of assessments were quashed by various tribunals and high courts, due to which there was amendment in Finance Act 2026 by introducing section 147A with retrospective effect from 1st April 2021, in which it was said that it is not the faceless assessing officer, it is the jurisdictional assessing officer who has to issue the notice under section 148. After this amendment, there was a doubt in the minds of various assessees and even the professionals that what will happen to those judgments where the tribunals or even the high courts have quashed the assessment proceedings on the basis of JAO FAO issue. So this is the first case which I know, which is on record now, where the tribunal has filed the appeal against the order of the Hyderabad ITAT B Bench by taking the plea that since the amendment has been made with retrospective effect from 1st April 2021, so the decision of the Hyderabad ITAT B Bench should be quashed on the basis that the notice has been issued by jurisdictional assessing officer and not by the faceless assessing officer, meaning thereby that the revenue was taking the plea that whatever the assessment order has been quashed, that decision should be reversed in lieu of the amendment with retrospective effect from 1st April 2021. When the court heard this matter, the court said that in the present case, when the Hyderabad ITAT B Bench passed the order, at that time the amendment was not there, so the finding arrived at by the tribunal cannot be either held to be contrary to the law as it then existing, nor it can be said to be contrary to the evidence on record. The court said that when the tribunal passed the order, at that time at least 100 of the judgments of even the Telangana High Court was available, which is the jurisdictional High Court in the present case. So there is no infirmity in the order passed by the tribunal. The court said that as far as the substantial question of law which is required in case of appeals to the High Court, so in the present case no substantial question of law exists. Friends, this case is a big relief to the assessees because where the assessments have already been quashed, and when the legislature tries to give a new life to those assessments which have already been quashed, especially bringing the amendment with the retrospective effect, so that can demoralize the assessees in taking the various steps where the orders have been quashed by the various tribunals and courts. Friends, if this view is to be taken, then this view is very helpful for the assessees where even the assessments have been quashed on the basis of mechanical approvals, whether under section 151 or 153D, because there was a big doubt in the mind of the professionals and even the assessees that what will happen to those assessment orders which have been quashed on the basis of section 148 notices or on the basis of 151 approval or 153D approval. So this case can be a very leading case where the appeals of the revenue should not be accepted in the High Court. At the end of this video, once again I am repeating the name of the case. The name of the case is Principal Commissioner of Income Tax Hyderabad versus Vinod Ojha, and this case is decided by the Honorable Telangana High Court on 23rd June 2026, and the reference of the case is ITTA number 92 of 2026. Thank you, friends.